evening, Mr. Chairman and members. Ed Howard, representing the Deposition Reporters Association. Very briefly, with the Judicial Council requiring official court reporters in 2007 to take continuing education, the only licensees who operate in the legal profession without continuing education benefiting consumers now are the freelance deposition reporters. With that, I'll turn it over to Tony Pallone, who is the Legislative Director for the Deposition Reporters Association.
Good evening. My name is Tony Pallone. I'm here on behalf of the Deposition Reporters Association of California. We are the only trade association in the nation specifically devoted to the needs of the freelance licensees that are addressed in this bill. I myself have been a licensee for over 33 years, and I've owned a deposition firm in San Jose for over 29 years. And as an agency owner, I sort of have a dual role of being not only a licensee, but sort of a consumer of licensees' services. And so I've been able to see on a firsthand basis the need for continuing ongoing education by freelance reporters, how critical that is. As the analysis that you have on the bill mentions, my official colleagues who are directly employed by the court and who work directly for judges in the courtroom have, since 2007, at the direction of the Judicial Council, been required to take 8 hours of continuing education every 2 years. And the case for continuing education in my segment of the profession is equally compelling and equally needed. There are, for example, unique ethical issues that we have to face as freelance deposition professionals who must try and both solicit business from law firms while at the same time maintaining our strict neutrality and impartiality between those attorneys that we work for and their adversaries on the other side of cases. And millions of dollars can be at stake when litigation can get very personal and contentious and bitter. Also, the technology in our profession has changed drastically. In the years that I've been working, when we first started, we used to dictate our steno notes onto tape, and then it was transcribed by transcriptionists. Then we went to computer-aided transcription. Then we began to offer a computer-aided transcription with hookups to attorneys and judges so they could see the instant translation of our steno notes immediately before them, which dramatically speeded up the process for everyone involved. Now we can deliver transcripts online. We have online transcripts repositories. We can take our real-time translation feed and send it out over the internet so participants across the nation can play a part in a deposition without having to attend in person. All of that technology requires additional ongoing education that may not be received at the time of your basic training as a court reporter. What we do also is not only take dictation, but have to be at least marginally familiar with a good number of technologies and sciences. We have to be able to master the jargon of neurosurgery one day and mechanical engineering the next day and geology the day after that and aeronautics the day after that. All of this requires ongoing and critical education. And we also have to be constantly upgraded on the new updates to all legal changes and ethical changes that court reporters must be critically aware of. What we do is very important in the legal process. One wrong word could mean the difference between punitive damages and none being awarded, the difference between the life and death of a small business or of a reputation or of even a life. That is why it's necessary that we be licensed, because what we do is really very difficult and very important, and continuing education has to be a part of that. Every other licensee in the legal profession must undergo continuing education to ensure their ongoing competence and to protect the consumers of our services. It is equally important for deposition reporters to do the same. As a small example, some years ago, the Court Reporters Board instituted a new regulation to protect the consumers that required minimum transcript formats. That meant that every consumer of our services could be assured that there would be a certain number of lines on a page of the transcripts we produce and a certain number of words. There were, unfortunately, many licensees who were unaware of that law and were not observing it. If we had minimum CE requirements in place now, I'm absolutely certain that every one of our licensees would know that. For all these reasons, I ask for your aye vote in the vote. Thank you.